Thank you, Abu, for joining me today.
Thank you so much, Perpetua. I'm delighted to be on this show today.
Definitely, same here. I mean, while one might say Minister Wike often finds a way to dominate headlines, this particular action raises serious policy and legal questions. I mean, let's begin with the concept of ground rent. There are those who might want to know what exactly we're talking about. I mean, what exactly does it mean? Who is required to pay it, to whom, and how does it differ from standard rent?
Okay, the idea of ground rent is very straightforward. Under land holding all over the world, there are two means by which you can own a land. You know, in some other jurisdictions, they practice what we know as the freehold system. However, in Nigeria, we practice the leasehold system. Now, under those systems whereby they practice the freehold system, the government allocates land to you and it becomes yours entirely. However, under the leasehold system, which we practice in Nigeria, the property is actually leased to you. So the idea of I own this property, I own that property does not exist, is abstract. So what happens is that the government leases the property to you for 99 years. And in turn, what you're expected to do is for every year in that 99 years, January of every year, that you pay an amount known as the ground rent. You pay to the government. Is the rent you pay for that lease. And this rent is a statutory rent under the Land Use Act. Now, when a person intending to own a property within the FCT, for instance, let's restrict ourselves to the FCT since that is the topic. The minister, one of the powers that the minister has is to allocate such property, you know, through an offer of statutory right of occupancy. Now, under this statutory right of occupancy, there are conditionalities, there are conditions for the crystallization of your ownership. The first is that you must accept the offer. The second is that you, at some point, you'll be called upon to pay for certificate of occupancy. Another requirement will be that the development you will carry out on this property will be in accordance with the term of grant. For instance, if the property is allocated for residential use, you are expected to construct or develop that property in line with the term of offer. Another condition, which is the most important, is the payment of ground rent. Now, if you fail to fulfill any of these conditions, it becomes a ground or the basis for a revocation. So ground rent is the rent paid in respect of a property, in respect of the land, which is leased to you for 99 years. So you're expected to pay this rent every year, January of every year, else you risk revocation. So in short, this is what ground rent entails.
I mean, that's quite interesting. I mean, I'm being told that we have a development right now in connection to what we're talking about. Please confirm if we have that video so we can just show the world what's happening right now in Abuja. That's the FCT, of course, where we're supposed to see this revocation take place. We're talking about the Federal Capital Territory commencing repossession of 4,794 properties in Abuja from today being Monday, the 26th of May, 2025. And that, of course, is what is happening. That we have a reporter on ground who is monitoring and giving us updates. So that's the visual you're seeing right now on your screen. And of course, that's what we're talking about. And you've heard from the barrister, the lawyer himself, talking about what all of this means and why this is happening right now. All right, barrister, thank you so much for staying with me. All right,
Thank you.
Yeah, sadly, a good number of these occupants are government agencies. How do you describe a situation where this money has not been paid for so long? I mean, is that impunity, corruption, systemic oversight failures, or what exactly do we call it? Because the people we're targeting today are those who have not paid from 10 to 43 years. There are those who are still want to, 10 years, that theirs is a case for another day. I mean, but for today, going forward, we're looking at 10 years to 43 years. How do you describe that?
No, it is not short of impunity because, Nigeria is one country whereby everything goes. And we Nigerians, we tend to be lackadaisical about things until we are pushed. Now, from the time the Honorable Minister started the implementation of this ground rent, you would notice that there has been huge compliance across board. There has been huge compliance. A lot of people have come forward, following the publication of the various file numbers on the newspaper. A lot of them have come up to pay, while some persons, continue to remain insistent on not paying. So it is nothing short of impunity. And what is shocking is that government agencies, such as the NTA and some other
NNPC,
CBN are complicit. It's so unfortunate. It's so unfortunate that government agencies are even complicit. And I think the minister needs to be commended. Because if for 43 years, agencies of government are not complying with the requirement of payment of ground rent, you ask yourself, what were prior ministers doing for the past 46 years? And Matthew, this is the primary source of revenue of the Federal Capital Territory Administration. You can see development going on in every aspect of the city. You can see flyovers, you can see road construction, you can see development, housing projects, going on. So, and you ask yourself, where will this revenue come from? So it is sad that, the predecessors of the current ministers did not see the need to enforce this. You were offered statutory right of occupancy. You saw the condition there that if you fail to pay ground rent, you risk revocation. And at the end of the day, the property is revoked. What do you expect? So I think the minister must be commended. And to answer your question, it is nothing short of impunity.
All right. I think apart from impunity, you also said something that sounds like systemic oversight failures, because to some extent you blamed the delay or whatever it is that's happening now on the fact that maybe previous ministers were just overlooking. I mean, you can't only blame these agencies. You also have to look at the FCT administration that probably didn't do its job or didn't get those guys to pay what they were supposed to pay at that point in time. But of course, we will take a break now, and when we'll come back, we will continue this conversation. All right, we'll be back after this short time out. Glad to know you're still with us, and we're still talking about the FCTA repossessing some premises. And of course, we showed the visuals from FCTA where that is currently ongoing, just as the administration had promised. Thank you so much, Arome, for staying with me.
Thank you.
All right, just before we move on, I just want us to clarify this. What are the legal steps the FCTA is sort of mandated to follow before revocation and repossession? Would you say all these steps have been exhausted before we move on?
Well, the Minister of FCT, or rather the FCT administration, has done well by publishing the file numbers of the respective properties, giving them 21 days to comply. Of course, some property owners came forward and complied, but some failed to. The necessary notice by that publication, the requisite notice, has already been issued to them, right? And the provision under the Land Use Act, as well as the terms, if you look at the regular template of a statutory right of occupancy, the conditions are there that if you fail to pay, the property or the allocation is liable to be revoked. So as far as the conditions, the statutory conditions are concerned, the minister or the FCT administration met all the conditions, except the allottees whose properties have been revoked can come forward with evidence of payment of ground rent, at such date prior to the date of revocation. In that case, they can as well approach a court of law to ventilate their grievance. And of course, the court will look at the case on its merit and reverse such allocation. So, but as far as the provisions of the law is concerned, or the requirement of the law is concerned, I think by the publication which the FCT administration has done on various national dailies repeatedly, calling on allottees to within 21 days come and comply. This is aside the 43 years of non-compliance. This, to my mind, qualifies as good notice, and it's in tandem with law.
Right. We understand that some property owners have gone to court. Shouldn't this sort of restrict the FCTA from going ahead with its intention, or what legal instruments would typically be required to halt such a process?
Well, it is the right of every Nigerian to approach the court to ventilate their grievance. Whether your case has merit or not, the court is bound to look at it on its own merit. Now, it is a good thing that they've approached the court. It is also necessary for them to obtain an injunction restraining the minister from acting in respect of those properties that have been revoked, because you know how the administration works. Before you know it, those properties will be reallocated, which is within the discretion of the minister to do. So by approaching a court of law, obtaining an interim injunction, restraining the reallocation or dealing with that property pending the determination of the substantive suit. Because of course, like I said, there is a possibility that some persons have complied, some persons have paid, but for some reasons, maybe their payment has not reflected. They can approach a court and have the court look at those proof of payment, look at their case on the merits, and decide whether their allocation was done within the confines of the Land Use Act. So, in essence, it is within the rights, and it is the prerogative of every aggrieved Nigerian to approach the court. Of course, the case will be looked at on its own merit.
Interesting. I see where you sort of stand in all of this. But of course, another thing I just want to bring to your attention is this. I understand these 4,794 properties are business premises. What immediate and cascading economic losses could this seal off cause for businesses, employees, and the broader FCT economy if there isn't an immediate resolution?
Well, we need to also understand that justice is a three-way traffic. Within the civil premises, for instance, there's justice for the claimant, justice for the defendants, and of course, justice for the government. Now, we understand the economic hardship that these entities, the corn oil and the rest, are likely to suffer by this revocation. However, we also need to advert our mind to the fact, due to the deprivation of revenue to the FCT administration. This is the primary source. Ground rent is the primary source of government revenue because it is paid across 99 years, every year. And the government, the FCT administration, has been deprived of ground rent. In some cases, we hear 43 years. You and I know what the ground rent assessed for the period of 43 years, assuming they were paid, the kind of development that would have come to the FCT, the kind of facelift that we would have seen, assuming it was paid. So while considering the loss that these business entities are likely to suffer, which we admit, as well as their employees, they are going to, most of them might become jobless very soon. And the general economic hardship that the business is likely to suffer, some of those businesses are likely to fold. We admit that. However, this is a very good source of revenue for the FCT administration. So like I said, justice for the claimants, justice for the aggrieved party. So, but one way or the other, let justice be seen to be done.
All right, thank you so much, Arome. My director says it's over. I mean, we're done with this conversation. I had a lot to talk to you about, especially seeing the visuals, but we have to end it here. Thank you so much, Arome, Managing Partner, the Counsel L-P, for your time on the show today.